My name is Chris O'Connor and I'm the Director of O'Connor, Ruddy and Garrett Solicitors. And thank you for taking the time to listen to our short video today on if a oral promise can hold up after someone passes away. We often receive inquiries from people where they feel there was something not right about how someone's estate is to be distributed. Some feel they have been hardly done by when someone dies and they have not received what they were told they would receive from that person while they were alive. So, can an oral promise hold up after someone dies? The answer is yes, in some circumstances. There is a remedy in law which we use as a way to enforce that promise against a deceased person's estate. In law, it is called a testamentary promise, or specifically called promissory estoppel. To be successful in proving a testamentary promise, you must be able to demonstrate to a court that 1. Someone makes a promise or a representation. 2. That promise or representation was relied on. 3. The person that relied on the promise suffered detriment as a consequence of relying on the promise. 4. The detriment that was suffered was reasonable in the circumstances. And 5. That relying on the promise, it would be unconscionable or unfair if the deceased estate was not bound by that promise. To give you a scenario where this happens is historically with rural properties. That is, a father will say to one of his children, "If you work on the farm and help me when I get old, I will pay you a smaller wage than what you would otherwise receive if you're working in a similar role, but when I die, I'll give you the farm." So when the son then relies on that promise and the representation by the father and continues to work, normally huge hours for minimal pay, although when the father passes away and the child finds out that his father has gifted, for example, the farm equally to all of his children, and not just the child to whom the promise was made or the representation was made, the child would be able to bring a claim against his father's estate, claiming a testamentary promise. In this instance, the father has made a promise to the child that if they work on the farm for minimal wage, they will receive the farm on his death. The child has relied on the farmer's promise to continue to work on the farm and receive a wage which is under market value. So in this scenario, the detriment is the loss of the wages. But detriment does not have to be purely financial. Courts have included psychological and other health impairment, or in some circumstances, a loss of an opportunity as detriment. Further, because of the detriment suffered by the child, it would be unconscionable or unfair for the estate not to be bound by the promise. That is, unconscionable or unfair largely depends on the specific circumstances of the case. Although in this current scenario, the child worked and arguably improved the value of the farm and the land, and therefore it would be unfair for the estate not to honour the promise. So in this case, the court would find the farm should be given to the child. The scenario can also apply to a promise to care for family members, as the application of this particular action is endless. I take many inquiries from people where they say what they have received doesn't seem fair or right. If that is the case, please contact our office for a free initial claim assessment to determine if you have a claim, as there are many different solutions we can use to claim what you think you're entitled to. Thank you.